Good morning or good afternoon to everyone. Thanks for coming to our webinar, Preparing for the California Consumer Privacy Act, Practical Ways to Mitigate Risk and Develop Litigation Defenses. Before we get started, just a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer these during the webcast, but if you need a fuller answer or we run out of time, we'll answer later by email. A copy of today's slide deck, as well as other reference materials, are available on the resource widget on the screen. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical questions located in the help widget at the bottom of the screen as well. This webinar is CLE accredited in California and Illinois for 1.0 general credit and in Missouri for 1.2 general credits. We award CLE based on attendance for the entire 60 minutes. From time to time, you will be required to click a pop-up screen to reflect your continued engagement with the webinar. Your certificate of attendance will be emailed to you later this afternoon once your attendance has been verified. We value your opinions and appreciate your participation in the course today. So, first of all, we have three presenters on today. We have a great presentation on an important topic, and thankfully my co-panelists are quite good. I'm Jim Shreve. I'm chair of the cybersecurity practice here at Thompson Coburn. I've been practicing in privacy and cybersecurity for over 20 years. Like my colleague Luke, I come from a financial services background, but I advise clients in many different industries. I do a lot of work on incident response, but also on proactively mitigating risks from security incidents through improving policies and procedures, agreements with third parties, conducting tabletop exercises to prepare for incidents, as well as on privacy issues about whether it's permissible or advisable to share, collect, or use personal information or other sensitive information. Luke.
Hi, everybody. I'm Luke. I'm a litigator. I'm based out of Thompson Coburn's Los Angeles office. I've been a litigator for almost 15 years now, and I've spent the last 10 of those years representing companies and mostly financial institutions in various litigation, various consumer litigation. Everything from lending to debt collection, credit reporting, loan servicing, and really anything in between that relates to a financial institution's interactions with its customers. So over the course of my career, I've been often asked to advise in the context of litigation on my clients' use and disclosure of private consumer information. And in the last couple of years, it's really developed into advising clients regarding the litigation risks specific to collecting and using consumer information. And I think it's safe to say that the CCPA, which we're going to be talking about today, represents kind of the next step in terms of the potential liability that that folks might face. So thank you again, and Robert.
Great. Hi, everyone. My name is Robert Fowler. I'm the Director of Professional Services at Jordan Lawrence and Xdero Company, and we help organizations address their regulatory, compliance, and litigation risks. We do this by providing practical and effective solutions that help them develop and maintain data inventories, automate data subject access requests, establish defensible deletion programs, and address third-party data privacy requirements. I've been at Jordan Lawrence for 15 years. I've worked closely with general counsel and CISOs and CIOs and chief privacy officers to help them, and their companies comply with expanded data privacy regulations. And I'm so excited to be a part of this conversation today.
Thanks, Luke and Robert. On the plus side, we clearly bring plenty of experience here. On the downside, it's also clear we're all getting older. So moving into the presentation, privacy requirements are ramping up all around the globe. Certainly from the EU, we've seen the Data Protection Directive replaced now by the General Data Protection Regulation, which significantly ramped up privacy requirements on those collecting personal data from data subjects in Europe. We have strong and strengthening requirements in Canada. Certain APEC countries in Asia and Pacific are improving and strengthening privacy requirements, and we're seeing it in several areas of South America as well. And so, not surprisingly, those concepts and demands for privacy are finding their way into the U.S. And as we're going to discuss, a lot of that is happening at the state level. At the federal level, privacy in the U.S. is largely a sectoral exercise. But at the state level, they tend to be across the board requirements that apply regardless of industry. And that's what we've certainly seen in California. California has long been a leader in both privacy and in cybersecurity, but most particularly in privacy, having enacted the California Online Privacy Protection Act many, many years ago that led to a pretty much national standard for online privacy notices, the Financial Information Privacy Act, Shine the Light Law, several California requirements. At this point, there's in the U.S. a perception that not a lot is getting done in Washington, and so you have states like California stepping into the void. And what you're also seeing in industry is that some entities that previously had resisted regulation of privacy are now much more amenable to it, in part because they're having to comply with some of these requirements outside the U.S. And some companies are genuinely concerned and want to protect privacy, and others, I think, see a competitive advantage potentially in having tighter controls on privacy in the United States. So I think it's often useful when you're looking at a law to understand how and why it was enacted, and I think that's particularly helpful when you're looking at CCPA. California has long been a leader in privacy. There are provisions in the California Constitution. You have the Song-Beverly Act. And then just a couple of years ago, there was a push to have a ballot initiative that was significantly backed by a guy named Alistair McTaggart. And so this ballot initiative would have appeared on the November 2018 ballot. They acquired enough signatures to get onto the ballot, and that ballot initiative would have introduced a privacy regime in the state that was even similar to what we see under CCPA, but in certain respects even stronger. And just honestly, when you put something like that on the ballot, if you ask consumers, do you want more privacy or less privacy? Most prognosticators thought that the ballot initiative probably would have passed if it had been on the ballot. But there was a compromise struck just days before the deadline to remove the ballot initiative from the ballot. So legislation was drafted and passed in just a few days. And as a result of that very rapid process, there are very clear issues that in many of which became apparent right away with regard to the statutory language. Unclear definitions, provisions that don't hang well together. And so there were some amendments that were enacted in September and October to mitigate some of the more difficult provisions of CCPA. I think the most important of these relate to employees' data and B2B transfers of data. And also, an important thing here in the background of CCPA is it gives rule writing responsibility to the California Attorney General's office. which is an unusual position to put the AG's office in. I mean, most often, California AG's office does have rule writing authority, but that's unusual and is usually not the primary responsibility of an AG's office. They generally don't write rules, they sue people. But the AG's office took this on. They pushed to get some additional funding so that they could hire people in to write the rules. They conducted several public hearings on CCPA and the rulemaking process, and then issued draft rules on October 10th of this year. And there's an open comment period for the rules, which will close on, at least at this point, on this Friday. So if you want to submit comments, you're going to have to do that very soon. So that's where we stand on it as of today. And so, when does what are some of the key dates then for CCPA as we go forward? Luke, do you have some thoughts on that?
Yeah. So I guess the question is, so when do we start the care? And I think the real answer is probably some time ago. A lot of the processes that we're going to be talking about today really require groundwork that takes some time to implement. But the effective date of the statute is January 1st, 2020, which sure, I don't have to remind folks on the phone, is less than a month away. So that's when the statute actually takes effect. That's when covered businesses are expected to comply with its provisions, and that's also when the statute becomes privately actionable. We're going to get into that a little bit later in the presentation as to the scope of the private right of action. The quick version is that the private right of action is currently limited to data breaches. But again, in terms of compliance, the date to keep in mind is January 1st. It's a little bit different for the enforcement piece, and Jim, do you want to expand on that?
Sure. As I mentioned, the Attorney General's office is in the rulemaking process, and so they need to take in and digest all of the comments to the draft regs, which are going to be significant and already are, we know. And then figure out how to amend the regs and release them. So just as a practical matter, it seems very, very unlikely that the Attorney General's office is going to be able to issue a final reg by January 1st, given that the comment period hasn't even closed yet. And so enforcement begins 6 months after the regs are published, or July 1st. So it's looking pretty likely that it's going to be enforced from July 1st. So what does that mean? Well, it means that a lot of these unclear provisions that we're still trying to work out, and the AG is still trying to work out, could be enforced even potentially before we have the regs issued. I think most people believe the regs will be issued final regs before July 1st. But it's not impossible that it could be pushed out beyond that point. So I think that creates a real quandary for entities. So if you're thinking about what should we be doing, I think one important point here is that enforcement of the CCPA is likely to be largely complaint driven. And so who's likely to complain? Well, I think one group of people would be those who make a request under CCPA to enforce their rights and are ignored. So when we get to January 1st, I think it's going to be important to make sure if you get a verified consumer request, VCR, that's an important term of art, know when that comes in, think about how you're going to verify it and how you're going to respond, even in the absence of the final process from the AG's office. And I think one of the things also you need to think about even before that is a lot of the requirements of CCPA look back over the prior 12 months. And so if you're getting a request in January, think about, are you going to be able to respond about what you were doing a year ago? That's something you may need to think about, even before we get to January 1st. So as we get into this, it would be helpful to know CCPA, it's not sectoral, it cuts across a lot of industries, but the effects won't necessarily be equal across all industries. So it would be good to know from you from what perspective you're viewing CCPA. So if everybody could click on the best industry to describe your company, we'll put up results in just a few seconds. If you could just quickly put that in, and we'll see what the results are here in just a moment. Okay, let's see what the results say. It looks like tech and financial services are the most common ones, but also with some in insurance, manufacturing, and media. That's good to know. I mean, I think tech companies are likely to disproportionately get requests in this space, and with financial services companies, including insurance companies, there are interesting, complex issues about to what data they have that CCPA applies. One other question for everybody. We'll talk about the applicability of CCPA, but it'd be good to know from you which of these three statements best describes where you are. Are you based in California? Are you based elsewhere but have operations in California? Or three, do you have no current operations in California? If you could go ahead and put in an answer and submit. And just while we're waiting on that, we did get a question in from Frank about whether a nonprofit corporation in another state but doing business in California will be subject to CCPA. And I think the answer is that very consciously legislators carved out nonprofit entities, and so you have to look to how it's defined here. But carved out nonprofit entities from the definition of business, although they clearly do want to get, if you're for-profit and not necessarily located in California but doing business there, they want to cover that as well. And so, but even if you're not subject to CCPA directly, you certainly might experience effects from it, because quite oftentimes, businesses now are acting as service providers to other businesses, and so you may be downstream of CCPA. You may find some of the requirements pushed onto you by your business partners. So looking at the results here, we have a strong majority to not in California but having operations there, and that's not so surprising. CCPA is going to be felt nationwide. It's going to have far-reaching effects. So with that, CCPA applies to a business, and as I mentioned, it covers for-profit entities, so only for-profit entities, and then it looks to that collects consumers' personal information, or on the behalf of which such information is collected, and that alone or jointly with others determines the purposes and means for processing of consumers' personal information. So it's looking to, are you collecting information or having the information collected for you? Are you for-profit? I will note that it covers nearly any type of structure of enterprise. So whether you're sole proprietorship up to corporation, if you are an entity, and so it cover any kind of legal entity, you're a business within California CCPA. You have to do business in California and then satisfy one of these three thresholds that are on the screen here. So more than $25 million in annual revenue, personal information on 50,000 California consumers, households, or devices annually, or derive more than 50% of the revenue from selling consumers' personal information. So a broad range of companies that the legislature intended to cover here. And then, two other important terms, consumer and personal information. So to be a consumer, you have to be a natural person. So it doesn't cover business entities, only covers individuals. As far as California residency, it looks to the tax code to determine who's a resident. Now, I would note, talks about however identified, including by a unique identifier. So you don't necessarily need to know, and we'll get into this with personal information, who the information relates to. If you could know, if you could identify them, CCPA is trying to cover that kind of information. And I would also note here, particularly for those in the financial services space, where consumer is quite often defined as someone who obtains a product or service for personal, family, or household purposes. That's not how CCPA is written. You can have a consumer who is obtaining or applying for a product in a business capacity that can be covered under CCPA. And the definition of personal information is also quite broad. It looks to could reasonably capable of being associated with an individual, and could reasonably be linked directly or indirectly. This is extremely broad language. It reflects current privacy concerns about not only identified data but identifiable data, and this is similar in approach to what the GDPR did. I would also note that it talks about linking back to a consumer or a household. Household here is kind of a unique approach. It's not defined in the law, but it is defined in the draft regulations, where it's defined as a person or group of people occupying a single dwelling. Note it doesn't say that they need to be related. So it raises the question, what about where you have tech workers in Silicon Valley? They're renting rooms or floor space in a house. Are they going to qualify as a household? And how are you ever going to know this? There are a myriad of difficult questions to be thought about under CCPA as we move forward. So with that, CCPA creates consumer rights. Luke, do you want to tell us about that?
Sure. So now that we've covered broadly what the CCPA applies to, is the consumers and the type of information covered, the next logical question is, what does it actually require covered businesses to do? And there's really two components or two halves of the CCPA. So on the one hand, it grants consumers certain rights with respect to the data that covered entities collect about them. And then the other half is it imposes on those covered entities certain responsibilities with respect to their interactions with the consumers. So let's start with the consumer's rights. And a lot of these are somewhat self-explanatory. There's the right to know. Consumers starting on January 1st will have the right to ask covered businesses what categories of information these businesses collect about them, as well as, in some instances, the specific types of information that companies collect. There's a right to access, which just means that consumers will have the right to ask that companies provide access to send them the information that they've collected, including for data portability purposes. There's a right to deletion. There's the right to opt out of the sale of data. This is a really big one. Starting on January 1st, consumers will have the right to demand that their data that's been collected not be sold. And the last two are, more substantive than even responding to consumers' requests. The first is the right to equal treatment. And what that is the right to not be discriminated against based on a consumer's exercise of one of the other rights granted by the CCPA. So the idea being is you can't penalize a consumer for exercising his or her right to delete or his or her right to opt out of the sale of personal information. There is a pretty big exception, some have argued swallows the rule, that a company may charge a different fee or price for a product or service if the value of the consumer's data to the business is reasonably related to the price difference. The regulations require, if you're going to do that, the newly published regulations require you to come up with a valuation method and disclose it. A lot of questions about that, and you need to be really careful in terms of what value you're assigning to that data and how you're disclosing that to consumers if that's something that you're going to do. And finally, the right to security. This is probably most in my wheelhouse in terms of the right to be free from data breaches. And really what that means is that consumers have the right not to have their information publicly disclosed, have the right to trust that the entities that they're doing business with are implementing reasonable security procedures to ensure the security of data. Okay, so then the other half. The other half is, well, what are businesses required to do with respect to consumers? The first is provide compliant notices. Businesses are required not just to explain to consumers their data privacy practices, including the categories of information collected, disclosed, and sold, but also specifically their rights under the CCPA. The regulations and the law both require disclosure to consumers of both their rights and how to exercise those rights. So you need to tell consumers, if you're a covered entity, how exactly they can go about submitting a right to know, right to delete, right to opt out, etc. You need to respond and comply with VCRs. That's a term of art that Jim mentioned before. It stands for verifiable consumer request. That is simply a request coming in from a consumer seeking to exercise one of the rights afforded by the CCPA. It is a business's obligation to ensure that it can actually receive, respond to, and comply with those rights. So you need to develop processes to be able to do that. Maintain reasonable security procedures and practices, covered that, and keep records of compliance. You need to be able to document that you're complying with the CCPA. So how do we actually go about as a matter of practice? Well, we've developed, and we're going to go through a checklist, and I'll turn it over to Robert for step one.
Yeah, absolutely. So, we think that really one of the first steps in order to comply with any privacy regulation is you have to understand your data. You have to know what you have and where you have it. And so how you develop your data inventory and how you maintain that inventory, it directly impacts your ability to meet your obligations, to demonstrate diligence with regulators, and defend your compliance efforts against plaintiffs' attorneys. And so I want to talk about, what are the important elements of an effective data inventory and why it's so important. So you have to connect all of these critical elements, and it starts with knowing whose data you have, right? So we start with the data subjects, identifying the specific types of personal data elements you have on each data subject, and then connecting that to retention requirements, which are based on the types of records used across the organization. And we think of it that way and do it that way for two critical reasons. First, that's how business people think about their world. They don't really think about it in terms of personal data. And second, that's how retention regulations are written. They're based on the context of the records. So for instance, no regulation is going to tell you how long to keep social security numbers or profile data or preferences. You have to tie that personal data to the retention requirements. And then finally, you have to understand where your data is located throughout the business, from business functions and applications where it's being used, of course, to third parties as well. And the inventory enables compliance. It informs how your data can be used and protected. And understanding this not only limits exposure to a potential breach, but it also limits the time and resources spent early in the discovery process, especially when we start talking about data subject access requests. And so, it's important to understand that your inventory has to be kept up to date. I think this is something that a lot of organizations are beginning to realize. It's not a one and done sort of a process or a checkbox item. As more of these privacy regulations are rolled out state by state, you'll need to understand the personal data you have and maintain it based upon those requirements as well. So another really important piece is making sure you have this in a format that allows you to update this as needed is really, really critical.
Yeah. So the next topic, privacy notices. I mean, notice is an important part of CCPA. Here, the statute adds to the existing requirements of California Online Privacy Protection Act in regard to the online privacy policy. As I mentioned, California effectively set a national or even international standard for privacy notices for websites and mobile apps in terms of information that's collected online. CCPA expands this to cover offline collection of personal information. And so in that privacy notice, privacy policy, you have to disclose the specific consumer privacy rights that are created under CCPA. So the collection, sale, deletion of personal information rights, you have to be described there. The statute also mandates 3 different types of notice to be given to consumers. So notice at collection. So this has to be at or before the time that personal information is collected. That notice has to be visible and understandable to the consumer. It has to be accessible to those with disabilities, and it has to include a link to the Do Not Sell page if you have to put one on your website. There's also a notice for the opt-out from sale. So, describe consumers' right to opt out from the sale of their personal information. And we're not going to get deeply into it here, but sale is defined much more broadly than you might think. And then there's a notice requirement where you're offering financial incentives to allow you to retain or sell personal information. And I think many people thought going into that the CCPA types of notice could be combined into 1 or 2 actual notices that are issued or posted. But looking at the AG's regulations, they seem to take a somewhat different view, kind of looking at each of the categories of notice separately. And so I would say that the regulations make it a little bit less clear as to whether or not you can satisfy the CCPA notice requirements with a single notice or just a couple of notices. And based on what I've heard, I think there's going to be a lot of comments that go into the topic of whether or not you can satisfy multiple notice requirements with a single notice document going forward. And so, Luke?
All right, on to step 3. So as we mentioned, you need to develop a process to address VCRs, verifiable consumer requests. The regulations impose different timelines depending on the different type of request. The regulations require you to acknowledge receipt of requests to know or to delete within 10 days and to respond within 45 days. You can get one 45-day extension. On the right to opt out, you need to process those within, it's as soon as possible, but at most 15 days. And as part of that, you need to inform entities to whom you've sold information in the last 90 days that the consumer has exercised his or her right to opt out, and so that they can abide by those wishes as well. And one of the points I think that's important here is that the rights both to know and to delete have certain exceptions. The right to delete, there's a whole list of exceptions of circumstances where you might not have to comply with a request to delete. For example, it's necessary to perform the service that the client is requesting. The regulations contemplate responses, no responses. The regulations contemplate entities responding to right to deletion requests, and in some cases the right to know requests for particular types of information, with letters that explain to the consumer why the entity cannot comply. So in addition to creating template letters or template responses that inform consumers of the information that you've collected or confirm deletion, companies also need to develop template no responses explaining why particular requests cannot be met. So as a practical matter, what does this require? And Robert?
Yeah. So this is really a challenging task, and I can tell you that this is something that we are having a lot of conversations with our clients and prospective clients about right now, which is how do we manage these verifiable consumer requests, or another term for them is a data subject access request. And so, as Luke mentioned, you have 45 days to fulfill a data subject access request. So the question you need to be asking yourself is can we respond to these requests in a timely and cost-effective manner? And a recent Gartner report revealed that up to 85% of companies felt they're not ready to comply with this much feared provision. And so it's something really worth thinking about. There's some really concerning issues too when it comes to fulfilling and managing these. There can be, hidden lawsuits lurking in these data requests that could enable valuable discovery for prospective plaintiffs. And these new rights also open up organizations to unintentionally compromising personal data and cause a breach if you don't have an effective, streamlined process and technology in place. So for instance, if you accidentally provide someone else's personal data to the wrong person, you now have a breach on your hands. And so when it comes to operationalizing a data subject access request, there's 6 critical capabilities that you have to be able to address to ensure that you have an effective solution. So first, you have to have a dynamic portal to accept the varying types of these requests. And what we've seen is if you have an open-ended method, you can effectively manage and expedite the request to the right people within your organization, and so that can be troublesome. 2, as I mentioned earlier, DSARs are the perfect target for social engineering to gain unauthorized access to personal data. So it's really essential to build a strong authentication process to verify a data subject's identity before proceeding with a request. And that to me is really, out of these 6 items here, that might be the most important, is really making sure you can verify that that person is who they say they are. The third, under CCPA, these have to be fulfilled within 45 days, right? So you have to be able to outline the different request scenarios that you could receive from different types of data subjects, develop the workflows to be able to manage these in a time-sensitive manner. 4, you have to search for and collect and produce the personal data that you hold on the data subjects. That's a requirement. And so that includes personal data across applications, email, shared drives, paper. If you have it, you have to produce it. 5, you have to establish a process to review and redact information before handing it over to a data subject, right? You can't give Robert's personal data to Jim or to Luke. And so you have to do that to ensure that you don't cause a breach inadvertently by commingling data. And then finally, number 6, before fulfilling a deletion request, you have to have insight into any active legal holds or retention regulations that would require you to reject the deletion request and be able to adequately communicate that back to the data subject. So those are the 6 things we want you to be thinking about, and there's no doubt that the plaintiffs bar, they're going to leverage the complexities of this regulation to their advantage, and we're really, the message is for organizations to really be prepared.
All right, step 4, develop a record-keeping protocol. This one is somewhat straightforward, although a couple of interesting things. So this is solely a creature of the regulations. This is something that the Attorney General came up with almost exclusively, really allowing or requiring the company to keep records so that the Attorney General can ostensibly monitor compliance. You need to keep records for 2 years. And one interesting provision is that consumer requests for specific pieces of information, and this is distinguished from categories of information. So if a consumer requests a particular piece of information that your entity might be holding, and there are certain ones that you can't disclose, including Social Security numbers and the like, but requests for specific information require a sworn declaration from the consumer that the consumer is he or she is representing to be. The Attorney General has explained that provision by saying that there needs to be some consequence or some downside to fraudulent or false requests, although it's a little bit unclear who's actually going to be pursuing these folks. My thinking is if a fraudster is a fraudster. I'm not sure a declaration is a terrible deterrent, but I guess we'll see.
Thanks, Luke. So third-party agreements. Several of the CCPA requirements are going to necessitate working with other entities to achieve compliance. You may not collect all of the personal information you're receiving from a consumer directly from the consumer. Some of it may be collected for you by third parties. You may have third parties that are enhancing personal information for you, like in lead services, which are, I think, turning out to be a big issue under CCPA. Another issue here is that CCPA creates benefits to where an entity qualifies as a service provider, as that term is defined, as opposed to a third party, which is another defined term. To be a service provider, an entity must have limits on their ability to use, share, or retain personal information that's provided to them under the agreement. So I think one thing to consider right now is how much leeway do your third parties have in their use of personal information that you provide or that they're collecting on your behalf, because that may influence whether or not they're going to be deemed as a service provider or a third party under CCPA. I think it's also going to be important to address how VCRs are going to be addressed relating to the service provider, a third party. If a request comes in through a service provider or a third party, how is it going to get to you? And if the service provider needs to cooperate in order for you to respond to a VCR that comes in, think about the kind of information that they're going to need to supply and the time frames in which they're going to supply the information to you. As Luke's going to talk about more in a moment, CCPA creates greater litigation risks than you may be used to under the Gramm-Leach-Bliley Act or HIPAA privacy requirements, and the possibility of greater liability. As a result of that, you should think about indemnification and limitation of liability provisions in your agreements with other entities, because those may become more important than they previously have been. Training is also important with CCPA. There are some express requirements in CCPA to ensure that individuals responsible for handling consumer inquiries to be aware of the CCPA rights. The draft regulations create requirements for a training policy on CCPA compliance and addressing consumer requests if you're an entity with 4 million or more consumers. In addition to this, just as a practical matter, there are many benefits to training personnel on CCPA. One is ensuring that requests get into the evaluation and response process, because the VCR can come in through a variety of channels, and you need to be able to respond to it. So making sure that it gets into that centralized process so that you can do the verification and respond in a timely way is going to be important. And then also in the timing of the response. I mean, it's going to be tough to make that 45-day deadline if the VCR itself is not escalated within the process for days or weeks. And it's also through training, you're going to get better and more accurate responses in customer service. I mean, partially or uninformed employees may give out incorrect responses to consumers who may call in or write in with a question. So, I think you also need to consider your insurance policies. CCPA creates the possibility for more litigation and for other risks. Cyber insurance policies quite often are focused on liability relating to the security of information. Here, most of the requirements of CCPA, although there are certainly requirements relating to breach notice, but it creates new requirements related to the privacy of information, so the collection, sharing, and use of information. So it may be good to consider if and to what extent that privacy liability is covered under the cybersecurity policy. And this is important both for you and in many cases for your service providers or other third parties with whom you're sharing personal information. So another couple of survey questions. Luke?
Yeah, I think we've come to the moment of truth. So the question is, have you completed all of these steps? And I'll just give it a minute or so.
Yeah, and in the meantime, we did get we did get a request in about the threshold, that $25 million threshold in revenue. Is that California only, or is it more general? And the statutory language doesn't say, and this has been a point of quite a bit of debate. I do think it's something, in the draft regs, it didn't clarify this point, but the statute does require the AG's office to consider the thresholds, including that threshold, every 2 years. And it certainly would make sense for them to clarify that point pretty early on, because I think that's a question that a lot of entities have.
So I think I've left this slide up long enough for that to sink in. We have 100% no. And the next question is, and the last of our survey questions, if you're working towards compliance, which of the steps have you found most difficult to complete? Which is the one that you're stuck on? And again, I'll go through quickly. Data inventory, okay. Again, 100%. I think that's also not terribly surprising. I think that's certainly the first step and likely the most important. So that's not surprising. So now we get to, well, for all the folks who answered no, which was 100% of our audience, what are the consequences of not complying? Well, there's two aspects to that. There's a civil penalty that could potentially be imposed by the Attorney General's office, and there's also the private right of action for data breach, and the possible liability is up on the slide. So in terms of the private right of action, as I mentioned just briefly before, it's currently limited to data breaches. The statute in its entirety is not privately actionable. There was an amendment at one point, 561, that the Attorney General proposed, or that was proposed that the Attorney General supported, that would have made the entirety of the statute privately actionable, including the notice provisions and the VCR compliance. It didn't make it out of committee, and it wasn't signed into law, which is not to say that it can't be introduced again. But again, currently the civil liability to private litigants anyway is limited to data breaches. So that leads us to the next common misconception of, well, my data security is good, I won't get breached. And Jim, do you want to speak to that?
Yeah, and the answer is actually you will, you have, and you will be. That I've worked on well over 1,000 incidents. I mean, it's amazing the number of ways it can come about. Just a couple of interesting examples for those of you in the Northeast may remember this one. A few years back, the Boston Globe had that when you put out newspapers, they'll oftentimes put paper over the newspapers themselves to protect them when they're in the bundles. Well, an environmentally conscious employee decided to reuse these long tractor feed sheets in the office for this, and it turned out that the tractor feed paper had financial account information on subscribers. And so the newspaper trucks were speeding around Boston one morning trying to recollect all the newspapers that had been put out, hours before. Something that did involve a client. Blowing across the parking lot. They look at the papers and they're full of non-public personal information on customers that had been just put into a dumpster. And so the examiner turned right around and headed back inside. And lately, we've seen many more incidents happening at third parties because of increased reliance on third parties, particularly cloud service providers. So breaches are going to happen. It's a question of not a question of if they're going to happen, but of when.
Okay, so the next logical question is, well, if you're going to get breached and you're going to be subject to private litigation from a data breach, how does the CCPA apply and how does it change things? I think we all know private data breach litigation is already happening. It's been happening for a long time. And really the answer is that the CCPA simply provides a different basis to bring these sorts of lawsuits, which is significant in a couple of ways. So the current theories, or some of the current theories underlying data breach lawsuits include negligence. That's simply a common law theory saying you had a common law duty to act reasonably with respect to care of my data and you didn't. Unfair business practices, those are mostly state UDAP statutes. That's for the regulatory and compliance folks on the phone, that's UDAP with 1A, which refers to the state level unfair and deceptive acts and practices statutes. And breach of contract. These cases have been brought before as breach of contract cases where through a contractual agreement, a party was obligated to somehow safeguard your data and failed to do so. So how does the CCPA change things? Well, the first and highlighted point, statutory damages. This is a really big one. The CCPA, as we talked about before, imposes statutory damages for data breaches, which has been a difficulty for the plaintiff's bar in getting these cases kind of over the hurdle to the large payouts. And I think a good recent example of that that just came out a few days ago is in the decision involving a Facebook breach from September 2018. Judge Alsup of the Northern District just declined to certify a damages class as well as a damages issue class in that case, finding that the damages that the plaintiffs had proposed in that case were not specific enough to support a common law negligence claim, and as to the damages issue class certification, the court held that that individual issues would prevail and declined to certify a class, at least on those points. That case would most likely have turned out differently if it had been brought under the CCPA, both under the typicality and commonality of the damages issue and in terms of and in terms of damages being available by statute and therefore not uncertain. Also affects standing. Again, to the litigators on the phone, I think a lot of folks know that standing has been a well-used and, although diminishing, at least initially successful defense to data breach suits. This is the idea that to bring a case in federal court, you need to show actual injury, and folks whose data has been disseminated but who felt no personal impact yet haven't been damaged and therefore can't maintain their case in federal court. Again, with a statutory private right of action, I think that defense is going to be further weakened. And the statute, the last point, is an attack on arbitration and class action waiver provisions. The statute actually includes a provision banning contractual provisions that would limit the way in which consumers would enforce these rights. It doesn't actually state arbitration or class action waiver, but there's a general understanding that that was the legislature's intent. Again, we'll see what happens with that. I think there's a fair argument that such clauses in general are preempted by the by the FAA, but it's going to be an interesting area of litigation as we move into next year regarding whether arbitration provisions and purporting to limit these types of claims survive. So I'll just leave this up for a moment, or feel free to review later, but on the statutory right of damages, we just put up a couple examples of recent data breach settlements and the per user value of the settlement versus how many folks were breached, and you can kind of draw the comparison. So the statute itself does provide some defenses to these types of claims. Jim, do you want to start us off on those?
Sure. In connection with the breach notice provisions, there certainly are some defenses to consider in advance that may avert or at least mitigate your liability. Encrypted data is exempted from the definition of personal information in the California breach notice statute. Although encryption is not defined in the statute, I think it's certainly best to employ encryption that meets an established standard like NIST, or is at least considered standard in the industry. Redacting information can have a similar benefit under the statute. We mentioned about information that's not subject to the private right of action. I don't really want to get into the weeds here, but an interesting construction issue in CCPA is that the breach liability provision references a definition of personal information that's in a safeguarding requirement of the statute rather than the breach notice requirement itself. And so it creates the possibility that the definitions aren't going to sync up exactly. As I said, that's deep down into the weeds, although I'm sure a court will be looking at that at some point. Another thing you can do is we'll talk about this a little bit more in a second, but maintain reasonable security. And then there's this idea of curing a breach, which Luke, do you have anything you'd like to talk about with curing a breach?
Yeah, well, I think we'll get into it in a second, but I guess the statute does provide a statutory cure period in general for violations of the CCPA that does purport to apply to the data breach. But as we'll discuss in a minute, it's not clear, and it's actually quite confusing what exactly it would mean to cure a breach. So, open question.
Okay. So this certainly raises the idea, what are reasonable procedures and practices? There are a lot of sources you can draw from. I don't think any of them are definitive. There's a whole long line of enforcement actions that have been taken by the FTC that allege entities have failed to employ reasonable security. What's reasonable nearly always depends on the nature and scope of the risks and their effectiveness, sometimes the cost of controls. But I would say that quite often these cases, nearly always these cases settle. So the complaint and the consent order provided only limited facts that you can draw from. But I would say in general, certainly in the expectation of government entities and regulators, that what is reasonable is becoming increasingly specific. And so I would note the current revisions that are being considered to the Gramm-Leach-Bliley safeguards rule by the FTC. It pulls in several of the controls that are discussed in those cases, and then some others that are pulled from the New York cybersecurity regulation. So we're seeing, what's reasonable in the past might have been a more general proposition, but is becoming increasingly specific. One thing that is pretty specific is a few years ago, the California Attorney General issued a breach notice report, and in it, it said that reasonable security includes the 20 controls that are often cited as the CIS 20. And then the problem being when you get to that kind of specificity is not always do all controls make sense in all situations. So that makes it a little more difficult. You can also look to several publications that are put out there, like NIST. We've got 800-53, 800-171, or the Cybersecurity Framework, the ISO 27001 and 002 frameworks as well. But in general, I'd say having something external that you can point to that's known and respected, you can say that we adhere to that. It gives objective evidence towards reasonableness, as well as it can ease the compliance and oversight burden that you're going to have under CCPA as well.
All right. So I think, we definitely wanted to cover potential defenses, but an important point is that the defenses are not absolute. It is not the end-all to come into court, especially in a private lawsuit, and say that we've complied with X standard, therefore we're reasonable and we're fine. Ultimately, in the private litigation context, what's reasonable is going to be determined by the trier of fact. And I included a case, LabMD versus FTC, is kind of an example of that. So this was a case out of the 11th Circuit. It was an FTC enforcement action that resulted in an FTC order against LabMD, which is a cancer screening company that experienced a breach, requiring the company to implement reasonable security practices. That was actually the FTC's order following the enforcement act. And the company challenged it, including on the grounds that it wasn't definite enough to comply with. And the 11th Circuit opinion ultimately vacated that order based in part on that argument. But the really interesting, or one of the interesting parts, was that the court went through an analysis of how exactly such an order would be potentially enforced by the FTC in court. And the scenario that the court laid out was that a judge or trier of fact, a judge in this case, would be presented with the question of, is the subject, is LabMD complying with reasonable practices? And LabMD would put up an experienced expert to say yes, and the FTC would put up an experienced expert to say no. And ultimately, it would be really for the court to decide, or the trier of fact to decide on an ad hoc basis, what's reasonable. And I think really, more so even than the holding, that's the point, which is reasonable is, to the extent that you're leaving it to the trier of fact, it's not an absolute and shouldn't be looked at it that way. Same thing with respect to a cure, which, as I said, is really undefined. And really just interesting point on that, the new data privacy proposal that Alistair McTaggart's organization, Californians for Consumer Privacy, has proposed for the 2020 ballot, actually specifically addresses this and states that after the fact cures, so after a breach, revisions to a policy or cures to whatever process defect led to the breach are insufficient to shield an organization from liability based on the cure provision. So again, no current definition, and the new proposed law already states that after the fact will not suffice. So in light of that, what can you do? Robert?
Yeah, so I think one of the things that's really critical is to have less personal and sensitive data around, especially data that you're not required to maintain. And so a best practice approach to reducing risk around maintaining this sort of data is to have less of it, right? So having a defensible document retention program in place is critical to reducing volumes of unnecessary data and risk. And unfortunately, most companies are keeping this kind of data much longer than necessary. And the FTC, they have a saying that I love, and that the saying is they said, personal data you don't have can't be breached, you don't have to produce it for litigation or data access demands, and you don't have to protect it. So the moral of the story here is have a defensible document retention plan in place, make sure business people are eliminating and disposing of records and data based on the retention requirements, and it'll really put you in a much better position when trying to comply with these regulations. And then the final piece here we just wanted to share with you is just kind of a some thoughts on and some general highlights and takeaways of our session today. One thing I recommend, of course, and we saw it in one of the survey polls, is having a data inventory. I think we can all agree that it's something that is the baseline of any compliance program, is understanding your data. And so, my takeaway or key thought for this session today would be to ensure that you have your inventory in place, and from there, you're really able to leverage that to make a lot of really good and smart decisions on how you're going to ensure compliance with these regulations. Jim and Luke, any thoughts or key takeaways from your perspective?
I would second your thought on doing the inventory, mapping out your data, knowing what you have, where it is, how it's used. It's hard to do too much if you haven't done that.
Yeah, and from a litigation perspective, encryption and data minimization, I think, are the 2 points that you raised that are probably the most critical in terms of limiting your liability.
I do want to mention that we have this compliance checklist that's available on the site. I would urge you to use it as a tool. It's a useful tool for you. Don't look at it as necessarily as a check the box exercise, but look at it as a number of things to think about in terms of CCPA compliance requirements and what you're doing and what you know about what you're doing. This is going to evolve and be updated over time, so I'd encourage you to look back. And then I would note that we got a number of questions in here, well more than we were able to address during the presentation itself, and so we'll respond to those after the webinar. We'll get in touch with you about those. And I would also note this is the first of a series of webinars, and we're going to delve into these topics in greater depth as we go through smaller chunks of CCPA and how to comply with it. I would certainly urge you to reach out to us if there are particular topics you'd like us to cover in those subsequent webinars. Particular issues that you're struggling with, let us know, and we'll try and accommodate that as we go forward. And I would like to thank my two co-presenters, Luke and Robert, for all they've done. Thank all of you for coming, and we look forward to speaking with you sometime soon. Thanks, everyone.